Article 370, some 8 days of hearing has already taken place in the Supreme Court. We've heard
10 days. 10 days. Not 10 days.
10 days worth of hearing has been completed. Well, I've been so busy with the
Chandrayaan and
Chandrayaan that I have lost count of the. I was in fact going through.
In fact, you've become, you've done so much of research on this Pragyan, Chandrayaan, the entire mission. You can actually pass the exam on it.
Yeah, well, I mean, astrophysics, that ship, my friend, has sailed, I think, now. Now I think it's going to be deep space tourism. That's the only way I'm going to be able to make it to space. Astronaut, that's not happening. There's a latest tweet by ISRO. I'm going to play that out later in the show before we wrap up. But right here, Article 370, that hearing, now the government has given its voice. It says Article 370 was amputated to save the nation. AG R. Venkataramani says, by general law, the life and limbs of every person must be protected. In case of a medical emergency, often a limb is amputated to preserve a life, but a life is not given away to protect a limb. We cannot postulate a situation where end justifies the means. The means should also be consistent with the end, is what the Supreme Court replies. So, Varghese, how does one essentially understand? We were cycling back to that permanent temporary debate.
I was actually
coming to that. We were cycling to the Jammu and Kashmir Constituent Assembly, the Jammu and Kashmir Constitution, Article 370, Clause 3 in Article 370, which gives President the powers to revoke, abrogate Article 370, but that has to be in concurrence with the Jammu and Kashmir Constituent.
And that assembly doesn't exist.
That
1957 it doesn't exist. So there's only one in this, they had called it the two-key formula, I think. But anyway, so what happened is that right now what we see is that the court is trying to bring clarity to all those debates. One, what was the role of the Constituent Assembly of Jammu and Kashmir? What is the role of the Indian Constitution on Jammu and Kashmir once Jammu and Kashmir has acceded to India? Why is India's constitution takes preeminence over Jammu and Kashmir's constitution? And if that was the case, then you have Article 370 being a very temporary nature, in the sense that that Constituent Assembly was only facilitating the acceding of Jammu and Kashmir, the Kingdom of Jammu and Kashmir, towards India. So after that acceding has happened, you don't require that to be in place, and therefore 370 was removed out completely. So that was the arguments that are going on. So the permanent nature, the temporary nature, I think the court has come to the point that it is a temporary feature as such. And therefore, the preeminence of the Indian constitution is important.
It's not right to say the court has come to this. The court has questioned the permanency
yes,
of,
I would say, okay.
They have questioned it. And apart from that, I think the bigger question, ladies and gentlemen, now is going to be that the Union government on Thursday, when it tells the Supreme Court that removal of Article 370 to scrap special status of Jammu and Kashmir had become imperative to save and preserve the sovereignty of India, that is going to be the prime question.
We'll have to look at that aspect. In fact, Article 370 had existed in a manner contrary to Indian constitution. It was there as because when it comes to India's constitution, what we say is that it is applicable to the whole of India, and they have the constitution of Jammu and Kashmir was technically, and it was not fitting into that entire topic as such. So I think from 1957, since the Constituent Assembly is gone, there's only one representation when it comes to
Tushar Mehta finally entering the fray. Tushar Mehta said that petitioners challenging the abrogation of Article 370 are hiding behind the garb of this uniqueness of the accession of Jammu and Kashmir. They're saying other princely states also had pre-1947 statutes. How Jammu and Kashmir is unique, ladies and gentlemen, is because, Kapil Sibbal and all the other lawyers representing the batch of petitions that were against the abrogation said that Jammu and Kashmir had a constitution before, being becoming a part of the Union of India. Jammu and Kashmir had a constituent assembly. That's why it's different. No other princely state had a constitution. But Tushar Mehta here says that petitioners challenging the scrapping have tried to create an illusion by citing the uniqueness in the existence of the state's constitution prior to the signing of the instrument of accession. Not just Jammu and Kashmir, 62 princely states had pre-1947 statutes.
They had, for example,
but do statutes account for constitutions, Varghese?
No, they become a series of laws of governance and the laws of how the government is run, who is the head of the government and all that. See, Jammu and Kashmir is a princely state. and there were several princely states. There was Mysore, which was a princely state. There was Cochin and Travancore that were princely states. So Hyderabad, of course, joined in later, in a much different form of integration. But anyway, all these princely states, when they acceded to India, they cease to be princely states. They become part of the Republic of India, the Union of India. And later the Constitution of India becomes the supreme law book, or rather the governance book for that country. So I think Tushar Mehta is making that statement as such. And you can't say that there is Jammu and Kashmir is the only unique aspect of it, because it was a princely state that acceded to India. So like any other princely state that acceded to India, it would be looking for a complete integration.